Amen.
Counsel. Good morning again, ladies and gentlemen. How you doing today? Again, we just get right into this. This is not a complicated case. This is a very simple case. Okay? This is a case about self-defense. And not just self-defense of oneself, but we're talking about self-defense of one's family. Okay? Please pay close attention to the facts in this case. Every fact is very important. May 9th, 2022, Lawrence Dority was celebrating Mother's Day with his family at his father's house. Not very far from where this incident occurred. Okay? When he decided to leave, his father drives him home. Okay? Mr. Larry Dority is the driver. Lawrence Dority is a passenger, and his 10-year-old son is a passenger in the back seat compartment of his truck. Unknown to him, unexpected, as he arrives home, he observes a black Chevy, blacked out tinted window Chevy now parked outside his car. The lights, headlights on, car running. Okay? Out of concern, he starts to walk over to the car, and he starts to realize this car looks familiar to him. He believes it's the car of his long-term friend, maybe Sarah Walker. So this is the car that she has been wearing for months. It must be 6 months at a time. Mr. Dority didn't know that was about the car. He didn't know there was a boy in the car. He walks up, then tinted window rolls down. One can't see inside of the car. It's 1:30 in the morning. Dark out. Window rolls down. Mr. Dority asks, "Why are you here?" You want to know what happens next? Evidence will show that 6'8", at least 6'8", according to the medical examiner, he's 80 inches tall. Just like 6'8", without shoes on. Steps out of the car. Wingspan of 7 foot. With a threatening posture. Steps out. I'm smoking. What you want to do? What you want to do? Mr. Dority immediately retreats into his home. Gets his firearm. Evidence will show that he's a concealed weapon permit holder. Evidence will show he didn't go with the trouble. Trouble came with him. Right? His son is outside. He can't even make it into the house stage. He walks back out. But before that, he's still asking, "Why are you here?" You need to leave. Guess what happened next, ladies and gentlemen? Mr. Dority, after being threatened, walks into his home. He comes back out, and instead of Mr. Payne, the first one is Mr. Payne. His name is Adreian Payne. Mr. Dority didn't know that. He only knew that somebody named Adreian. He didn't know him personally. He didn't know him at all. Right? As he comes back out, not only did Mr. Payne not leave, but he pulls the car up closer to his home. So he had the opportunity to leave. And the evidence would show that his girlfriend, Sarah Walker, actually told him to leave. She had arrived at the tail end of the verbal altercation. Evidence would show she wasn't even present when Mr. Dority approached to ask him to see who he were. You heard testimony that she's going to say she's on the phone. She would admit to you that she told him not to come to the house. He did it anyway. The evidence would show he didn't even know where Mr. Dority lived. He circled around the neighborhood to find, he found Mr. Dority's car. He was familiar with it, he can say he's been for whatever reason. Mr. Dority comes back out, asks him to leave again. Not just that, why are you here? Simultaneously, as Mr. Payne reaches, Mr. Dority fires one shot, not to kill, but to repel the break. Evidence would show that bullet was pierced through the bicep into his chest cavity. Only then he got back in the car. See, you still standing outside the office. Okay? What did Mr. Dority do next? He didn't flee. He immediately told got his son, told him to get in the house, called law enforcement, reported to them what happened. Okay? He cooperated with the investigation. This is a case about self-defense. This is a case about defense of others. This case is very simple. The evidence would show that neither Mr. Lawrence Dority or Mr. Dority's fiance at the time invited Mr. Payne over. No one invited him over. The evidence would show that Mr. Payne's girlfriend advised him not to go, not to come. The evidence would show that the crime scene wasn't really secure. It was contaminated before law enforcement arrived. The state conceding in its opening just admitted that it was a weapon in the car. The evidence would show that that weapon, that knife, was not tested to DNA. Fingerprints was not even taken in evidence. The evidence would show that Ms. Tara Walker had access to that vehicle before law enforcement arrived. You would hear evidence that no firearm was located. But there is a reasonable explanation for that. Okay? Evidence would show that. The evidence revealed the inconsistency in the state's evidence in this case. It's abundance of it. The evidence revealed lack of evidence in this case. This is a clear case of self-defense. After you've heard and seen all the evidence, we ask that you find Mr. Dority not guilty. It's the right thing to do under these circumstances. This is not a case of a gunman on the loose, shooting bystanders and innocent people. This is a man that was on his way home, minding his business. Okay? This is not complicated. This is a case about a man who was forced to defend himself, his child, and his father against a much larger, aggressive man who showed up armed and threatening him at his home in the dead of the night, 1:30 in the morning. He didn't come singing a Christmas carol. He didn't come with any sense of kindness or respect. He came with intent to intimidate and threaten. And that's what he did. Evidence would show that Mr. Dority did what any reasonable person would do in that situation. Ask, Mr. Payne, why are you here? Mr. Dority asked Mr. Payne to leave. Did he leave? No. But more importantly, why was he there? How did you even know how to get to the house? Mr. Dority was threatened by him. He immediately went in his home and protected himself and his family. Mr. Payne postured himself in a threatening manner while outside of Mr. Dority's home at 1:30 in the morning. This is a case about self-defense. This is a case that the people of the state of Florida should recognize as self-defense. This is not acceptable. He's innocent. His actions are justified. After you heard everything, you prayed humbly and asked that you find out. That